Members of the jury, that brings us to the crimes charged, but before we address that, there was some evidence received as to whether or not defendant had a motive to shoot at the two complainants, and motive is that which moves a person to engage in conduct or to do an act. It is the reasons which motivate conduct. Motive may be good or bad. Criminal intent, on the one hand, is the state of mind which accompanies the criminal conduct or act. A person acts with criminal intent when his conscious purpose is to engage in conduct which the law forbids. Criminal intent is an essential element of the March 28, 2000 verdict, and once more, you will find either guilty or not guilty. Members of the jury, as to the events of November 11th, 1999, your verdict as to the charge of attempted murder of Travis Stroman, attempted murder in the second degree, will be either guilty or not guilty. If it is guilty, you will conclude your deliberations. As to the 6th and 7th and 8th charges, the assault charges as well, only if it is not guilty should you consider a charge of attempted assault in the first degree. Should you reach that charge, your verdict will be guilty or not guilty. If it is guilty, you need not consider assault in the second degree. Only if it is not guilty should you consider the charge of attempted assault in the second degree. Should you reach the charge of attempted assault in the second degree, your verdict once more will be guilty or not guilty. And finally, as to the charge of criminal possession of a weapon in the second degree on November 11th, 1999, your verdict will be guilty or not guilty. Now, ladies and gentlemen, I will ask you at this point to retire as to the jury room for a few minutes. Do not yet begin to discuss the case. It has not yet been submitted for your consideration, and you'll be recalled in just a few minutes. The panel has retired. We'll take any exceptions and further requests separately. First of all, any exceptions, Mr. Jacobs? Plaintiff's counsel, no, Your Honor. The court, any further requests? Plaintiff's counsel, no, Your Honor. The court, any exceptions, Mr. Gonzalez? Defendant's counsel, no. The court, any further requests? Defendant's counsel, yes. The court, proceed. Defendant's counsel, Judge, I think something appropriate should be said regarding the accomplice in the first instance in November 11th, 1999, Mark Perry. Obviously, he is not before the trial. At the very least, I would like the jury not to speculate about his whereabouts. The court, was he ever arrested? May it please, the plaintiff's counsel, may it please the court, Mr. Foreman and jurors, the defendants have been indicted by the grand jury, charged with the crime of assault in its first and second degrees. The first count in the true bill alleges that on the 12th of August, they assessed one James Ronald Shreet with weapons unknown to the grand jury with an intent to take his life. The second count charges that they assaulted him with weapons calculated to do grievous bodily harm, which is one of the forms of assault in the second degree. The third count charges that they assaulted him and indicted and inflicted grievous bodily harm upon him, which is another way of assault in the second degree. The issue of facts here is very simple. On the 12th of August at about 1 a.m., an automobile was being driven by James Shret, the complaining witness. In that automobile, there were 6 passengers, 3 men and 3 women. I think that you will realize when you see them that they are all respectable people. In other words, they were not a drunken party. There is no charge that anybody was intoxicated in driving that car. There is no charge that the people in that car behaved in a disorderly manner, so far as I have been able to find out. But the complaining witness is driving that car and did not get out of the line. There were 2 lines of traffic, one line for slow-moving vehicles and the other for lighter and faster-moving vehicles, and the complainant did go from the line in which he was moving into the occupied line by the slower-moving vehicles for the purpose of passing a vehicle in front of him, which was going more slowly than he was. He says that they sent him through that tunnel at a pretty fast clip, and that a person down in front of you, if he slows up suddenly, it is necessary to cut out in order to avoid collision. Whether that is put forward as an excuse by the complainant for going faster than he should have, I don't know. But for all events, and I will assume, for the purpose of this record, that he did what he should not have done and that he got out of the line. He was going along a few feet when he was called to a halt by Officer Brown, one of these defendants. For no reason, this stopped sometime. At 4 minutes and 38 seconds, it stopped.
Maybe you tapped it